It should be working. I should have set this up earlier, but I did not, because I wasn't sure whether or not I was going to feel like I had the time or the energy, but I do. So I am just going to share this to my, you know what? I pretty consistently get the notifications on my phone when I go live. So that is incentive. Because sometimes people are like, I'm so sad I missed it. And I'm like, I would not have, I don't have notifications on for very many people, I will admit. I would not have notifications on for myself if I wasn't myself. But it is very cool that other people do. But it makes it much easier now for me to share it. Okay, so quick live for the new motion to dismiss. Basically, I spent all day yesterday reading the new Hunger Games book, which I loved. Highly recommend. It's really, really good. But I wanted to be a little bit productive before my 4 p.m. appointment today. It's 2:22 where I am, and I have an appointment at 4. So I'm setting an alarm for 3:30, but I felt like I could get some work done between my appointment and now. And I love a late appointment because if I can't wake up early, it's much better to have an appointment late in the day. But 4 p.m. is so like middle of the day to me that I either don't do anything at all before a 4 p.m. appointment, or like if I have any kind of energy, I try to do something. So, hello! Oh, amazing. There's already people here. Perfect. I wasn't even this early to my own birth. Perfect. Welcome. Welcome, Valentina. Hello. Hello. Welcome. Okay. Okay. So I have the United States District Court, Southern District of New York thing. I don't know why I read that whole thing. What I have is the motion to dismiss that Ryan Reynolds filed about the Baldoni side complaint. This is posted on Baldoni Files Reddit. I always try to give credit to them. It's not where I get all my ideas, but it is a very, very excellent place to source things from. There are some really thoughtful and intelligent people hanging out in Baldoni Files. There are subreddits that call themselves neutral, or that say that they're just about the lawsuit or whatever, and anytime I look in the comments, anybody who's even remotely on Blake's side is immediately like swamped with downvotes. I would not participate anywhere other than Baldoni Files. I'll see something that makes me so mad, and then I notice that it's not from Baldoni Files, but it's from one of the ones that claims that it's neutral and is not neutral. That's my Baldoni Files plug. Oh, Absinthe Angel, hello. I also, there's probably going to be a lot of you I'm seeing in chat who I owe a response to on comments from live streams a couple days ago. I am planning on doing that. I had a little bit of energy to live stream, and I hadn't sat down and responded to comments, and this felt like more whatever. I don't really actually need to justify that, but my point is, you had asked me about the original characters that I mentioned on an earlier stream, and I do actually have fan art of them that my best friend that I write with drew of them. I would love to show you. I think that would actually be really fun to see somebody else draw. But anyway, that was a total side tangent. I'm so sorry. Okay. Checking comments. Rendered fat anti-woman is unfortunately a neutral position for most Redditors. Correct. That's really true. So I have not read this yet. I've seen a couple little choice passages from it. It seems like it's snarky. It seems like it also pulls from things that Blake's lawyer is saying and that Leslie Sloan's lawyer is saying, which is a real blow to the narrative on Team Baldoni that all of these many lawyers are somehow fighting with each other and that it means that Blake is going to lose. It seems like this is a team of very well-equipped people who are like actually working together. Also, I should have asked this sooner. Is the microphone good or is the microphone quiet? I should check. It says it's using the Yeti, so I'm just gonna trust it. So This is a motion to dismiss. Another thing about Reddit pretending to be neutral and then not actually being. I'm gonna go full screen for this because I think it's very funny. Hang on. So in terms of like anti-woman is neutral for Reddit. Okay, so in one of the neutral lawsuit ones, I was reading a thread and I wanted to pull my hair out because somebody was saying this complaint is it's the narcissist's prayer. I didn't do it, but if I did it, it's not that bad. And it's like that is literally the structure for a motion to dismiss. You write a motion to dismiss by saying, I didn't do it, but let's imagine I did do it. Here's why they can't sue me about it. You should dismiss it, Your Honor. That is literally what a motion to dismiss is. It is most likely also what Baldoni's side motion to dismiss would look like if they had done that rather than countersue. Or maybe they do also do a motion to dismiss. I don't know. I don't feel like I read specifically a motion to dismiss. But like Baldoni's complaint in a motion to dismiss also would be, I didn't do that, but if I did that, it's not illegal. That's essentially what his complaint is I didn't do that, but if I did, like that's legal. And they are reading a legal document and they are saying Ryan Reynolds personally wrote this in a very manipulative way. It's wild. It's wild. So I wanted there to be a place to discuss this, to discuss this where they're not going to be like, oh, this is this is the narcissist's prayer or whatever the fuck. All these people, they're saying so seriously, like I was reading it and somebody was like, I strongly believe that Ryan Reynolds suffered a narcissistic energy. And I'm like, what the fuck are you talking about? This is a workplace harassment complaint. Like, nothing about, like, narcissism or anything, like, should be coming into play. I don't even think that, like, necessarily arguing with, like, narcissism is the best thing on our side either for Baldoni, because while I would say he's very narcissistic and self-aggrandizing, I don't criticize him by saying he has a narcissistic injury and I'm an empath and blah, blah, blah. Like, it is just... Those are the people who think that they are critical thinkers and who are telling each other that they are critical thinkers. They are critical thinking into, like, using woo-woo shit like narcissistic injury and, like, projecting and diagnosing onto Ryan Reynolds. It is absolutely wild. It is inherently ableist. It is bad. And that's another reason, you know, I feel like I'm constantly justifying my choice to continue talking about this, even though I know a lot of you understand that, but that is another reason. Like, I want to talk about this where people are either going to stay on point or where I can ban them for not being on point. Narcissist prayer is just examples of Darvo, but with a pop psychology twist. Yeah, it's like, the pop psychology part specifically is where it loses me. On a side note, I missed reading the Southern Book Club. I'm sorry, I skipped a word there. On a side note, I started reading the Southern Book Club's Guide to Slaying Vampires. I hope you love it. I am very excited to know that more people are reading that book. I love that book. Yes. Yeah, points for throwing empath in there. Thank you. I'm glad you noticed. Label behavior, not people. Exactly. Absolutely. Yeah. Abuse of the word narcissism is a freaking epidemic. I agree. If anybody here has not watched the Sarah Z video from last year about, like, I think it's called The Narcissist Scare. I'm pretty sure that's what it's called. That is one of my favorite videos that came out on YouTube last year. It is so good. I think I have it in one or two of my recommendation playlists. But I highly recommend watching that video. It completely, like, it tears to shreds the entire, like, narcissist versus empath and, like, how, again, it's ableist and it's fucked up and it's bad and we don't do that here. But yeah, so I saw, hi Justine, I saw you asked if you missed anything. You did not miss anything. I basically was just explaining that I have to go at like 3:30. I have an alarm that will go off. But I had not started yet and I'm just about to start. But I did need to complain about the Reddit a little bit. Okay, so I'm gonna skip through all of this stuff about these are them citing other cases. Looks like they've cited a lot of them, and I did see in the Reddit also that they have like a habit of citing cases that this specific judge has already ruled on, which I think is a little bit funny. Like it's clever and it's smart, but it's like, okay, it's ass kissing in a way I appreciate, because I like that Blake Lively seems to have good lawyers. Okay, so introduction. Blake Lively sued Jamie Heath, Justin Baldoni, It Ends With Us, Jennifer Abel, Melissa Nathan, Wayfarer, and Steve Sarowitz, the Wayfarer parties, after they collectively launched a retaliatory social manipulation campaign to destroy and bury her because she privately spoke up about sexual harassment and inappropriate conduct that she and others experienced on set of the film It Ends With Us. So, what does Ryan Reynolds have to do with that? Okay, sorry. So, what does Ryan Reynolds have to do with that, legally speaking, other than being a supportive spouse who has witnessed firsthand the emotional, reputational, and financial devastation Ms. Lively has suffered? Nothing. That is italicized and bolded. Nothing. Mr. Reynolds is a defendant in this action for one reason and one reason only, because billionaire plaintiff Steve Sarowitz promised to spend up to $100 million to ruin Ms. Lively and Mr. Reynolds. The first amended complaint that Sarowitz and his co-plaintiffs filed seeks to fulfill that promise by polluting this court's docket with hundreds of paragraphs of clickbait designed for an audience other than this court, with virtually no bearing on cognizable legal claims. The Wayfarer parties have described the FAC as their most recent attempt to put all the evidence before the court and the public. That is a damning concession, given the lack of any actual evidence supporting legally cognizable claims against Mr. Reynolds. The Wayfarer party's so-called receipts include annotated excerpts, many with heavy redactions made by some unidentified person, of emails, text messages, videos, and photographs, such as large colored photographs comparing Mr. Reynolds' long hairstyle in a movie with Mr. Baldoni's long hair at some point in his real life. But the FAC is a pleading, not a gossip rag, and these so-called receipts fail to establish the requisite elements of a single one of the many causes of actions alleged against Mr. Reynolds. Damn! This is very good. I'm glad that I saved this for a live. Ryan Reynolds said, "Baby, I have Disney money now, just fucking try me." Sorry, I'm also, while I'm live, I'm chugging water because I'm getting my infusion later, and I have notoriously difficult veins for them, and I'm trying to make it easier. So when I stop, I'm drinking water. I hope that that's not gross for the microphone sound. Ass kicking in legalese is one of my favorite genders. Same. I try to use egotistical since narcissistic personality is a real thing, and yeah, y'all get it. Exactly. Yeah, egotistical is so much better than narcissistic. I attempt not to use, like, I even try to stay away from narcissistic. Like, I feel like I tend more towards, like, self-aggrandizing or whatever. Okay, so, hello. Oh, good. I'm really glad this timing is working well for people. Right. So let's continue. I also have been very confused about how the fuck Ryan Reynolds is in here, because, like, even if Nice Pool was about Baldoni, like, that's not illegal. So I've been confused. Because otherwise I feel like there have been many times when people have been mocked where they could have absolutely sued and didn't. Okay. The Wayfarer parties attempt but fail to assert 6 causes of action as to Mr. Reynolds. Each fails to plead facts sufficient to establish a prima facie, I don't know how to say, I know it's like Latin, right? But I don't know. Prima facie case as a matter of law. For example, the plaintiffs collectively assert a claim for defamation without pleading a single complete statement or identifying the time or place of such statement, nor can they, because no such defamatory statement exists. Also, I'm sorry for having roommates. You probably heard a door slam, but that's not because anyone's angry. It's just because the windows are open. It's beautiful out today. Further, the entirety of plaintiff's defamation claim appears to be based on 2 times that Mr. Reynolds allegedly called Mr. Baldoni a predator, but the FAC alleges no plausible facts that suggest Mr. Reynolds did not believe this comment to be true. Instead, the relevant FAC allegation suggests that Mr. Reynolds genuinely, perhaps passionately, believes that Mr. Baldoni's behavior is reflective of a predator. Even if the FAC plausibly alleged that Mr. Reynolds called Mr. Baldoni a predator while believing the opposite, which it does not, the law establishes that calling someone a predator amounts to constitutionally protected opinion. And suddenly the naming of eat predators makes a bit more sense, huh? A little bit of a roads leading back to Alexa moment. Okay. All right. So, where was I? Okay. And the FAC's thin-skinned outrage over a movie character, the satirical woke nice pool, does not even pretend to be tied to any actual legal claims. Instead, it falls into the FAC's general allegation of hurt feelings, which in reality is nothing more than a desperate effort to advance the same curated bully image that the Wayfarer parties created and disseminated in the retaliation campaign they launched against Miss Lively in August of 2024. All the other claims fail for similar reasons. The Wayfarer parties say that Mr. Reynolds extorted them, but fail to allege that he received any money or property. They claim he interfered with a contract without identifying what that contract is, what provisions were allegedly breached, or even which of them were parties to it. They assert $400 million in damages without explaining anything about who suffered that loss, in what proportion, as a result of which claims, or what proximately caused such losses. The FAC is long on hyperbole, prose, and claims, but devoid of any facts necessary to state ones recognized by law. It is, in essence, a burn book filled with grievances attempting to shame Mr. Reynolds for being the kind of man who is confident enough to listen to the women in his life and to hold her anguish and actually stand with her. The FAC is, in sum, a textbook retaliatory slap suit, and it should be dismissed with prejudice. I feel like I feel like I skipped a line there. I'm gonna read that again, because that was good, and I did not give it the delivery it deserved. The FAC is long on hyperbole, praise, and claims, but devoid of any facts necessary to state ones recognized by law. It is, in essence, a burn book filled with grievances attempting to shame Mr. Reynolds for being the kind of man who is confident enough to listen to the woman in his life and to hold her anguish and actually stand with her. Okay, that is the quotation mark in this. I thought it was anguish and actually, and I was like, that's confusing, but now I understand it. It brings me joy that Justin Baldoni definitely cried when this drops. Wonderful. I agree. I think he certainly cried. Yeah, that is so the quote here about confident enough to listen, this is all from, I think, from his Man Enough state, from his Man Enough. Yeah, footnote right here, why I'm done trying to be man enough. So that's why the quotation was like that. But this is a fantastic introduction here. I'm very entertained, and I'm very glad we did this on a live. Oh, hello, Drowsy Fun! Natalie, I'm a little behind, but re-narcissist rant. I see no value in diagnosing people as narcissists online. If what they did is bad, you can discuss that without the label. It feels very essentialist, IMO. I agree. All right. The Wayfarer parties have asserted a grab bag of claims against Mr. Reynolds and their FAC, including civil extortion, defamation, false light invasion of privacy, intentional interference with contractual relations, intentional interference with prospective economic advantage, and together intentional interference claims and negligent interference with prospective economic advantage. The Wayfarer parties claim that they have suffered no less than $400 million in compensatory damages, plus mental pain and anguish and severe and serious emotional distress. Not to mention hurt feelings, for which they posit they deserve additional compensation. FAC prayer for relief. Despite its length, the FAC alleges only a few isolated acts by Mr. Reynolds. With respect to the defamation claim, the FAC does not plead a single complete statement published by Mr. Reynolds. The only hint about the purported statements that are alleged to form the basis of the defamation claim in the following assertion in paragraph 325. The Lively parties made one or more statements to persons other than the Wayfarer party, including without limitation to the New York Times, to the effect that the Wayfarer parties engaged in, permitted, and or failed to prevent sexually inappropriate conduct toward Lively and others, and that the Wayfarer parties retaliated against Lively and others for reporting the alleged sexual misconduct, including by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. Only two allegations in the FAC even generously match that description with respect to statements purportedly published by Mr. Reynolds. Her publicist, Leslie Sloan, went so far as to propagate malicious stories portraying Baldoni as a sexual predator, a term Lively's husband, Ryan Reynolds, also used to describe Baldoni when he called Baldoni's own agent. Baldoni later received word that during the premiere of his movie Deadpool and Wolverine, Reynolds approached Baldoni's agency, namely an executive at WME, and expressed his deep disdain for Baldoni, suggesting the agency was working with a sexual predator, a phrase that uncoincidentally later appeared in the press, and, at a later date, demanded that the agent drop Baldoni. All emphasis added, together the predator's statements. Apart from those two statements, the totality of the FAC's allegations against Mr. Reynolds are that Mr. Reynolds, 1, demanded that the Wayfarer parties publicly apologized for so-called mistakes during production of the film, 2, was present during a meeting at the apartment that he shares with Miss Lively, at which he praised Miss Lively's version of a scene in Mr. Baldoni's presence, 3, allegedly contributed some writing of his own to the script, 4, admonished Mr. Baldoni for asking about Ms. Lively's weight and demanded that a scene be removed from the film. 5, attended a meeting with Ms. Lively to address her allegations of sexual harassment on set and demanded that Mr. Baldoni apologize for his conduct. 6, unfollowed Mr. Baldoni on social media. And 7, included the nice pool character in Deadpool and Wolverine that the FAC alleges was meant to satirize Mr. Baldoni's persona as a woke feminist. Legal standard. In reviewing a motion to dismiss, the court accepts all factual allegations as true and draws all reasonable inferences in the plaintiff's favor. However, this requirement is inapplicable to legal conclusions and threadbare recitals of the elements of a cause of action supported by mere conclusory statements do not suffice. A complaint must offer more than labels and conclusions, or a formulaic recitation of the elements of a cause of action, or naked assertions devoid of further factual enhancement in order to survive dismissal. Okay, argument. 1. The claims against Mr. Reynolds fail under both New York and California law. While the Wayfarer parties appear to agree with Ms. Lively that California law applies to the allegations in the case she filed, that does not answer what law applies to the Wayfarer parties' claims against Mr. Reynolds. The choice of law may vary by defendant and also by specific claim against the same party. To the extent that there is no conflict between California and New York with respect to the Wayfarer parties' claims against Mr. Reynolds, the court may simply apply New York state law. To the extent there is a conflict, as there may be with respect to the extortion, false light, and negligent interference claims, New York law applies to the claims against Mr. Reynolds, because New York is the jurisdiction having the greatest interest in those claims, given the way the Wayfarer parties pled the claims against him in the FAC. The FAC's allegations as to Mr. Reynolds focus solely on conduct that occurred in New York while he resided in that state. Whereas here, Mr. Reynolds' alleged torts are conduct regulating rather than loss allocating. The law of the state where the conduct occurred will typically apply. Further, unlike Miss Lively, Mr. Reynolds was never an employee of Wayfarer Studios, nor did Mr. Reynolds ever have, unlike Miss Lively, any contractual relationship with the Wayfarer parties, and therefore no contractual choice of law provision to apply. As set forth below, however, each of the claims fail under both New York and California law, and therefore the FAC should be dismissed with prejudice against Mr. Reynolds. The court should dismiss all of the 6 causes of actions as to Mr. Reynolds with prejudice. The FAC fails to state a claim for defamation against Mr. Reynolds. The defamation claim fails as a matter of law. It is fatally deficient because the FAC does not identify a single allegedly defamatory statement published by Mr. Reynolds, including either of the predator statements. Moreover, to state a claim for slander, a plaintiff must plead a defamatory statement of fact that is false, that is published to a third party, of and concerning the plaintiff, made with the applicable level of fault on the part of the speaker, either causing special harm or constituting slander per se, and not protected by privilege. The FAC fails to plead the claim in virtually every respect. The Wayfarer complaint does not sufficiently identify any defamatory statements published by Mr. Reynolds. Court should dismiss the defamation claim as to Mr. Reynolds because the FAC does not include allegations specific enough to afford him sufficient notice of the communications complained of to enable him to defend himself. I'm skipping over some of this case law stuff because I just want to make sure that I'm finished by 3:30. As this court has noted, it is only by pleading the substance of the purported communications that a defendant can challenge, and upon a motion, the court can determine the essential elements of a defamation claim under New York law, including whether the statement was false, whether it was capable of a defamatory meaning, and whether it was of and concerning the plaintiff. The FAC fails to sufficiently plead the substance of the predator statements, which are the only ones relevant to the defamation claim as to Mr. Reynolds. As to the agent statement, the FAC does not plead what Mr. Reynolds said, when he said it, or any of the context surrounding the conversation during which he purportedly uttered the agent statement. C8, stating only that Mr. Reynolds used the term sexual predator to describe Mr. Baldoni during a phone call with Baldoni's agent. The absence of these details makes it impossible, for example, to determine whether this statement falls within the applicable 1-year statute of limitations under both New York and California law for defamation. The sole allegation as to the executive statement provides only slightly more detail, namely that Mr. Reynolds and an unnamed executive at WME had a conversation during a movie premiere about Mr. Reynolds' deep disdain for Baldoni, suggesting the agency was working with a sexual predator. The FAC does not allege what precise term Mr. Baldoni used in this alleged suggestion, and, the sentence in which he allegedly suggested it, or any information about the context of the conversations, other than one of them was about how much Mr. Reynolds dislikes him for having sexually harassed his wife. Such bare-bones pleadings fail to satisfy Rule 8 and warrant dismissal of a slander claim. Okay, we've got more examples here. Predator statements are not defamatory because they are constitutionally protected opinion. The predator statements are an unactionable opinion. As a threshold matter, because there is no such thing as a false idea, courts must distinguish between statements of fact, which may be defamatory, and expressions of opinion, which are not defamatory. Instead, opinions receive absolute protection under the New York Constitution. The predator statements constitute unactionable opinion because they have no precise meaning, are not capable of being objectively characterized as true or false, and are merely a general reflection of the speaker's viewpoint. As another court in this district has explained, courts have recognized that words like scum, predators, greedy crooks, and criminals preying on street art culture are vague, imprecise statements of hyperbole considered non-actionable opinion. Use of colorful language, such as predator, victimized, or face of evil, are not actionable in and of themselves. The FAC fails to plead any facts indicating... Oh, wait, sorry, I missed one. The First Amendment principles ought to be obvious to, and even celebrated by, a group of litigants who have spent most of the past few months calling Mr. Reynolds and his wife bullies and liars. The FAC fails to plead any facts indicating that Mr. Reynolds' statements could be reasonably understood to have been assertion of fact, been an assertion. Assertion is not a word. Maybe I shouldn't be doing this while I'm rushing. I'm sorry to anybody who was under the impression I was a lawyer. Could be reasonably understood to have been an assertion of fact capable of being proven false rather than a pure opinion which is not actionable under the laws of New York. While the FAC fails to provide sufficient details about the predator statement, which alone is grounds for dismissal, the limited context it does militates in favor of finding a way in favor of a finding that they are assertions of opinion. The FAC alleges that Mr. Reynolds made the predator statements during a phone conversation with Mr. Baldoni's agent and at a movie premiere during a conversation with a WME executive during which Mr. Reynolds was expressing his deep disdain for Mr. Baldoni, which is utterly fatal under the opinion doctrine because it is plainly reflective of Mr. Reynolds' unabashed negative opinion of Mr. Baldoni's character. Alright, I think this looks really good. Okay. Mr. Reynolds has a First Amendment right to hold Mr. Baldoni, or any man who Mr. Reynolds believes sexually harassed his wife, in deep disdain, and the FAC does not allege any plausible facts that would remotely suggest, let alone establish, that anyone interpreted Mr. Reynolds' statements as reflecting anything other than his genuinely held belief about Mr. Baldoni's character. The court should dismiss the defamation claim as to Mr. Reynolds with prejudice, because the predator statements are expressions of opinion that deserve absolute protection by law. Okay. So sorry, I have just been letting chat run, but I'm seeing here. How dare you dislike your wife's harasser? Absolutely. Hi, Maggie. The bully counterpoint is so good. It's so good. It's so good. We're enjoying this. Thank you. I'm glad. You mean Ophi isn't paying? You mean Lively isn't paying for your law degree? I know. Okay. I'm gonna keep going. I definitely want to like come back and discuss this more later because I feel like there are really good conversations happening in the chat. But I'm gonna continue reading. We're on page 19 of 38, so I feel like we can do it by 3:30, honestly. Even if the predator statements were verifiable as fact, they are not actionable as defamation because they are substantially true. The Second Circuit has held that whether statements are substantially true is appropriate for resolution in a motion to dismiss because falsity is an element of New York's defamation tort, and falsity refers to material not substantially true. The complaint in this case must plead facts that, if proven, would establish that the defendant's statements were not substantially true. A statement is substantially true if the statement would not have a different effect on the mind of the reader from that which the pleaded would have produced. It is not necessary to demonstrate complete accuracy to defeat a charge of libel, and all that is necessary to demonstrate that the gist or substance of the challenged statement be true. The FAC includes numerous references to conduct that a reasonable observer could well consider predatory. In particular, the FAC relies on Mr. Baldoni's books, Boys Will Be Human and Man Enough, and his podcast, Man Enough, even going so far as to declare that anyone who knows Baldoni would have knowledge of the contents of Mr. Baldoni's books. See 195, relying on statements made on Mr. Baldoni's podcast. Those materials, with which anyone who knows about Mr. Baldoni would be familiar, include numerous admissions to behavior that could reasonably be described as predatory. See, for example, Jane Randall, Boys Will Be Human, a talk on healthy masculinity with Justin Baldoni, YouTube, March 7th, 2023, saying that I'm sure I have crossed boundaries and lines in my teens and 20s without even thinking about it simply because of the porn I was consuming. The Man Enough podcast. So this is like a bunch of quotes about him talking about his porn addiction, which I do think that is a way that people use to be inappropriate sexually, like talking about it as if it's like, oh, this thing I'm over, but then actually what they're talking about is they're just finding a way to talk about sex to somebody who doesn't want them to talk about sex to them. Like, that's for real a thing. Rest in peace to the intern that had to listen to all the podcasts. This has nothing to do with anything, but I dislike the studio's name Wayfarer because it sounds like mumbling. It is so hard to like actually pronounce that. I hate it. I hate it a lot. Also, I only just realized that I was really zoomed in on the complaint, so I'm sorry. We're 21 out of 38 pages in. Okay. I'm not calling out the porn industry, I'm calling out my relation to it, but I do believe that especially the porn industry, that the porn that young boys are watching is very violent, because no one ever sits us down and teaches us about consent. We learn it through porn. You, right, as a black man, or you as a woman, have had to put up with a lot of shit from people that look like me and or from me your entire life. And again, it could be laundry, it could be microaggressions for racism or sexism, whatever it is, I've done all of them. Justin Baldoni, man enough, undefining my masculinity. I wanted as a man to claim her publicly, as on some level I knew it would make me feel more like a man, emphasis added. While it is unclear what predator means to an average listener, it is quite clear that there is no discernible distinction between the gist of Mr. Reynolds' purported statements and the very behavior to which Mr. Baldoni has repeatedly confessed in public appearances, including that he spent years of his life mistreating women, which he attributes to a lengthy addiction to pornography, as well as openly describing his distorted conception of consent in sexual relationships. Were this case to go to trial, it would be Mr. Baldoni's burden to prove the factual falsity of the supposed allegation that he is a predator, but the law offers no principled basis for a jury to distinguish that label from Mr. Baldoni's descriptions of his own behavior. Whoa. That is really good. That is really well argued. This is really well put. I love this. Okay. I'm skipping over again some of the legal examples that they give. It would be perverse to permit Mr. Baldoni to build an entire brand, complete with a podcast, TED Talk, and books, off of his confessions of repeatedly mistreating women, only to turn around and sue Mr. Reynolds for $400 million for simply pointing that out in private, what Mr. Baldoni has bragged about in public. In light of Mr. Baldoni's own public admissions, of which the court can take judicial notice, the substantial truth document requires dismissal of Mr. Baldoni's defamation claims as to Mr. Reynolds. Yes? That's beautiful. Do you think it's good? Yeah. You're so pretty. The FAC fails to plead special damages. Dismissal of the defamation claim is warranted because the FAC does not allege defamation per se, but nonetheless fails to fully and accurately plead special damages with sufficient particularity to identify actual losses. This particularity requirement is strictly applied, as defamation claims will be dismissed for failure to allege special damages with the requisite degree of specificity. Far from fully and accurately identifying any harm that flowed directly from the injury to reputation caused by the predator statements, the FAC generally claims at least $400 million in compensatory damages without explaining what amount, if any, of that astronomical sum allegedly was suffered by Mr. Baldoni versus any of the other Wayfarer parties, or otherwise caused by the predator statements. And then some things to compare with the thing. The court should strictly apply the particularity requirement and dismiss the defamation claim for failure to allege special damages with the requisite degree of specificity. The FAC fails to plead facts demonstrating actual malice. As a public figure, Mr. Baldoni must plead facts demonstrating that Mr. Baldoni uttered the predator statements with actual malice. In other words, that Mr. Reynolds in fact entertained serious doubts as to the truth of his publication. The FAC's conclusory assertion that the lively parties knew that the statements were false or had serious doubts about the truth of the statements is a threadbare recitation of the legal element that is insufficient to sustain the law's heavy burden on defamation plaintiffs. Pleading actual malice buzzwords is simply not enough to nudge a case into discovery in one of these examples. Actual malice has nothing to do with bad motive or ill will, and may not be inferred alone from evidence of personal spite, ill will, or intention to injure on the part of the writer. Somebody should have sent that to Alexa when she was claiming that against Kat. Okay. It would be inconsistent with the FAC to find that Mr. Reynolds uttered the predator statements with actual malice. Indeed, there is not a single plausible factual allegation from which a jury could conclude that Mr. Reynolds does not believe Mr. Baldoni to be a predator. To the contrary, the FAC alleges that Mr. Reynolds took steps consistent with believing his wife's allegations, including demanding an apology from Mr. Baldoni and mocking Mr. Baldoni's woke feminist facade in Deadpool and Wolverine, not to mention Mr. Baldoni's own public admissions about his past conduct. The deep disdain that the FAC alleges Mr. Reynolds feels towards Mr. Baldoni concedes that Mr. Reynolds subjectively believes what he said about Mr. Baldoni, and thus defeats a finding of actual malice. What do you think? You think so? Can't believe she's just hanging out. Oh, okay. Okay, I won't scratch your chest. I know, and she's so beautiful back there. Hi, baby. Hi, baby. She's like just slightly out of frame. Okay. The predator statements are not of and concerning any Wayfarer plaintiff other than Mr. Baldoni. The predator statements refer solely to Mr. Baldoni and not any of the 6 other Wayfarer parties. To the extent that the FAC intends to assert the defamation claim on behalf of any defendant other than Mr. Baldoni, it requires dismissal because the predator statements are not of and concerning any of them. Wayfarer complaint fails to state a claim of false light. The FAC fails to state a claim of false light as a matter of law under either New York or California law. While California law recognizes claims of false light, dismissal is also required when, as here, the claim for false light invasion of privacy is duplicative of a defamation claim. It also fails because it appears to rely entirely on the alleged public disclosure of information on which the defamation claim is based. Finally, even if all of that were not dispositive, the false light claim fails as a matter of law for all the same reasons the defamation claim cannot survive dismissal. Civil extortion claim against Mr. Reynolds must be dismissed because New York law does not recognize extortion as a tort or any private right of action. This is like above my head because, again, Blake Lively is not paying for my legal degree, so I'm just kind of skimming again. The FAC is devoid of any allegations, much less particularized allegations, that Mr. Reynolds obtained any money or property from any of the Wayfarer dependents, or made any wrongful threat of prosecution, much less with knowledge of the falsity of the claim. And the same is true using the borrowed elements of criminal extortion. The FAC fails to allege that Mr. Reynolds either obtained any property or consideration from any Wayfarer defendant, because of course he did not, or did so through a wrongful use of force or fear. I don't know how I started saying wrongful. Okay, we got 10 pages left. The tortuous, the word is so hard for me. I'm sorry. I'm normally reading these things in private, and then I cut out all of the parts where I'm stumbling over my word. The torturous interference claims are duplicative of the defamation claim. As an initial matter, each of the torturous interference claims must also be dismissed as duplicative of the defamation claim. New York law considers claims sounding in tort to be defamation claims where those causes of actions seek damages only for injury to reputation, or where the entire injury complained of by plaintiff flows from the effect on his reputation. Whether Mr. Baldoni's alleged statements to WME are actionable in light of their claimed effect on Mr. Baldoni's reputation must fall as well under the pleading requirements for defamation. Nonetheless, each claim fails on its own terms as well. FAC fails to state a claim for intentional interference with contract. To survive a motion to dismiss, a plaintiff must specifically plead the existence of a valid contract and must identify what provisions of the contract were breached as a result of the acts at issue. So a lot of this, I think, is just Mr. Reynolds being like, what does this have to do with me at all, right? So I'm just skimming until we see things that feel more relevant to the things we talk about here. The FAC fails each of these requirements. The sole contract alleged in the complaint is a contract between the Wayfarer parties and William Morris Endeavor, WME, but the FAC does not allege any details about the contract, including which parties it allegedly bound. Surely not all 7 Wayfarer parties were parties to it. what the contract's terms were, or what provisions were allegedly breached. Strikingly, throughout the entire FAC, there is not a single allegation that WME breached its contract with any Wayfarer party, much less a description or quotation of a contractual term allegedly breached. Instead, the Wayfarer parties allege solely that upon information and belief, Ms. Lively and Mr. Reynolds induced WME to cease performing under its contract. But the cessation of performance is not the same thing as a breach of contract, and the Wayfarer parties, who have alleged the existence of this contract and are presumably in possession of its full terms, have utterly failed, after multiple tries, hundreds of pages, more media interviews than can be counted, and a publicly launched website, to identify any actual contractual provisions that they claim WME breached when it allegedly ceased performance. The FAC fails to state a claim for intentional interference with prospective economic advantage. In the absence of an allegation that a specific contract was actually breached, the FAC must satisfy the more stringent requirements for a claim of intentional interference with prospective economic advantage. It does not. To state such a claim, a plaintiff must allege it had a business relationship with a third party, the defendant knew of that relationship and intentionally interfered with it, the defendant acted solely out of malice or used dishonest, unfair, or improper means, and the defendant's interference caused injury to the relationship. Once again, the sole economic relationship alleged in the FAC is between the Wayfarer parties and WME, without specification as to which of the Wayfarer parties had such a relationship. The FAC does not even attempt to allege that Mr. Reynolds acted solely out of malice, as is required to survive a motion to dismiss, but the FAC itself asserts that Ms. Lively and Mr. Reynolds were motivated at least in part by a desire to seize control over a film production. Taking that allegation as true, as the court must at this stage whether or not it is true, such a motive, akin to normal economic self-interest, is inconsistent with the sole purpose of inflicting intentional harm, and insufficient to state a claim for tortious interference with prospective economic advantage. Nor does the FAC allege that Mr. Reynolds employed any wrongful means. To satisfy that element, as a general rule, the defendant's conduct must amount to a crime or an independent tort. I'm sorry, I've mentioned this before, I think in my video where I was talking about when I was talking about like all the abortion bills that I could research in one weekend. I get aphasia when my migraines are not well. When my migraines are not doing so hot. So like I'm about to go get an infusion later today that should help me, but I am at the I'm as far away as I like to ever be from getting my infusion that helps. So I'm mixing a bunch of words. I am of course more careful about my pronunciation in videos, but you're here live, so I'm sorry. Okay, where was I here? There's nothing in the FAC that amounts to an allegation of wrongful means. At most, the FAC alleges that Mr. Reynolds approached an executive at WME and suggested the agency was working with a sexual predator, and at a later date demanded the agent drop Baldoni. But sharp language, such as insulting a defendant by calling them a thief and a scumbag, is not wrongful or culpable conduct sufficient to qualify as wrongful means, and pleading the presence of false statements alone is not enough to support a claim for tortious interference. The FAC lacks a single allegation suggesting, let alone establishing, if taken as true, that Mr. Reynolds' alleged demand was anything other than an expression of sincerely held beliefs, which are neither criminal nor torturous under the First Amendment. The FAC fails to state a claim for negligent interference. A negligent interference claim must be dismissed because there is no claim for negligent interference with prospective economic advantage under New York law. And even under California law, the negligent interference claim is cognizable only where the defendant owes the plaintiff a duty of care, which the FAC does not allege. FAC fails to allege proximate cause. Each of the tortious interference claims must also fail because the FAC does not allege that Mr. Reynolds' alleged conduct proximately caused WME to cease performance. The FAC is silent as to how Mr. Reynolds, someone who does not own or control WME, could plausibly cause WME to cease performing its contract with Baldoni. Sorry, I'm adjusting my lights a little bit. I'm going to look worse, but I'm going to feel a little better. Finally, and regardless of the theory under which their claims are brought, the Wayfarer parties have failed to sufficiently allege damages. Merely alluding to damages in a conclusory fashion does not suffice. The FAC repeatedly asserts the Wayfarer parties were harmed and prays for a damage award of at least $400 million, but nowhere explains how or how much any of the Wayfarer parties were actually damaged by any of the alleged conduct in the complaint. An allegation that a claimant suffered damages without particular facts as to how she was damaged does not satisfy Twombly and Iqbal. Wayfarer complaint fails to allege conspiracy liability. Having failed to allege any plausible claim based on Mr. Reynolds' conduct, the FAC attempts to hold him liable on a conspiracy theory. That attempt fails. Under both California and New York law, a civil conspiracy theory requires that a plaintiff allege an agreement to participate in an unlawful act, or a lawful act in an unlawful means, an overt act performed in furtherance of the scheme, and an injury caused by the overt act. Conclusory allegations do not suffice. To survive a motion to dismiss, a complaint must contain more than general allegations in support of the conspiracy. Rather, it must allege the specific times, facts, and circumstances of the alleged conspiracy. Here, the FAC pleads no specific facts indicating the necessary agreement among any parties, any overt acts done in furtherance of such an agreement, and any damages. Even under the liberal pleadings of Rule 8, a complaint must do more than assert that defendants agreed to commit a tort. But that is all the FAC can muster. Read individually or as a whole, the FAC's allegations that Mr. Reynolds participated in a conspiracy to engage in torturous conduct against tortious conduct against any of the Wayfarer plaintiffs are utterly conclusory. They amount to bare assertions. C. Asserting that Ms. Lively was working with her husband, conspired to harm the Wayfarer parties by advancing a narrative in the press. Unsupported speculation. C. Alleging Mr. Reynolds apparently joined a campaign to extract concessions and creative control over the film by January 4th, 2024. Pure boilerplate. C. 322. Reciting elements of civil conspiracy liability. Attempting to recognize this deficiency, the Wayfarer parties confine each of their allegations of conspiracy to information and belief. Civil extortion, defamation, false light, intentional interference with contractual relations, intentional interference with prospective economic advantage. But that only confirms that the Wayfarer plaintiffs' conspiracy allegations fall short, because claims made solely on information and belief are insufficient to sustain a conspiracy theory. There is accordingly no basis to hold Mr. Reynolds liable on a civil conspiracy theory for any of the conduct alleged in the FAC. And then the court should award Mr. Reynolds attorney's fees pursuant to New York's anti-SLAPP law. Mr. Reynolds is entitled to attorney's fees under the substantive fee-shifting provision of New York's anti-SLAPP statute, which applies to the FAC's allegations against Mr. Reynolds for similar reasons to those articulated in the Sloan and New York Times motion to dismiss, both of which Mr. Reynolds joins and incorporates by reference. So again, all of the many lawyers is actually a good thing and not a sign that everybody's going to quit on Blake or whatever the fuck they're saying in the Reddit between speculating that she had a crush on him and Reynolds was jealous. Section 70A mandates a fee award in Mr. Reynolds' favor because, as discussed above, the FAC asserts causes of actions against him based on communications and in conduct in furtherance of a public and conduct in furtherance of an issue of public interest, namely Mr. Baldoni's and Mr. Heath's harassing workplace conduct and the subsequent retaliation, and cannot survive a motion to dismiss for failure to state a claim. Although this court reached a seemingly different conclusion in Brady versus New York Post holdings at Mr. Reynolds respectfully submits to the reasoning of Bob Linsky rather than Brady should control here for 3 reasons. I don't know how I ended up reading something in the middle of one of those case law things. I'm sorry. I'm just like bouncing because I'm like, oh, we're almost done. Okay. Last part. We're on page 37 of 38. So we're almost done and then I can check chat and then I'm going to have to run. The court should strike Exhibit A to the Wayfarer complaint or, at a minimum, disregard it. Mr. Reynolds joins the argument in the Sloan motion to dismiss, moving the court to strike the FAC's Exhibit A pursuant to Rule 12, as this court has recognized permitting a party to satisfy its pleading requirements by attaching documents other than instruments to the complaint would do considerable damage to Rule 8's notice requirement, including by requiring a defendant to hunt around in voluminous materials to figure out what the plaintiff alleges is relevant and supports its claims and what is extraneous. So I think Exhibit A, I'm 99% sure Exhibit A is like the timeline, like the big timeline, which we also should go over together on a stream. Even if the court does not strike Exhibit A, it cannot properly consider it to evaluate whether the FAC sufficiently states a claim. Conclusion, all claims against Mr. Reynolds should be dismissed with prejudice without leave to amend, and the court should award Mr. Reynolds his costs, including attorney's fees incurred as a result of the consolidated action. And then it's signed off. And these are names that I recognize. But okay, so again, thank you all so much for showing up, even though I was fumbling a lot of those words. Might have been better than reading it yourself. But you know, hello Sad Fox, hello. Okay. I am checking in here. Okay. No sorries, nobody's minds. Thank you. Stop apologizing. We're commiserating here. Thank you. Okay. Perfect. Awesome. Thank you. You have to be a famous man's man before Baldoni cares about your opinion. Absolutely. Yeah. These lawyers are extremely expensive, so enjoy that. Yes. I'm going to call you a predator and you're going to pay me for it. I love it when the right side has more money. Me too. If she had a crush and Reynolds was jealous, why would he call him a predator and not like a homewrecker? I agree. I completely agree. Yeah, probably expenses for Jad and all those people too. They're paying a lot of money, yeah. Respectfully submitted is kind of cute to me. I also read it myself. Yeah, I think you had asked me last night. I came up from my reading and crying hole from reading the new Hunger Games book, and I saw that you had asked if I had read it yet, and I was like, normally I would read it and then just kind of like incorporate it into a video or whatever, but you telling me that it was fun to read is why I was like, I should do this live. He's gonna take that man's production company, that podcast studio, all the royalties from book sale, and buy his kids ponies and some shit. It would be very funny if once Ryan Reynolds manages to get this whole "oh, nice pool is bullying" thing knocked out, if he then went on and continued to make fun of Justin Baldoni for a very long time. I would enjoy that personally. I would like it. All right. So yeah, we did get all the way through this here, and I shared this post from Baldoni Files in the description of this live. So if you're interested in coming over here and reading any of the comments here, this was also a very fun thread to read. I read through some of this thread before I read the whole complaint just now on live with you all. He should make a nice pool short and put it right on Disney Plus. I think displaying all of Baldoni's complaints in a numbered list just highlighted how petty and dumb they were. Absolutely. Ryan Reynolds is going to get nothing. Steph Jones is going to take everything they own way before Blake gets to pick through the bones. Blake Lively deserves a 5th push present for pushing this creep away from her for months. I would really, really love it if all of that infinite money that was promised to go into destroying Blake and Justin, if that got routed right into paying for everybody else's legal fees for all these fucking slap lawsuits. That would be so funny. A link for further reading. Hell yeah, absolutely. Yeah, like I've said before, I cannot recommend the Baldoni Files Reddit more, and I also cannot recommend staying away from the other ones more. But I do actually want to hop off so that I can find a sweater to wear, because I have to go get there, as people who have been here since I just started, I'm getting like an infusion, so not only do they need to get into my veins, but I also then need to sit there for like an hour, which is so boring, but it usually feels at least kind of good. So I'm hoping that it'll be like immediate relief, because sometimes when I've gotten my VFD infusion, I've like cried in the chair from feeling so much better, which is why I normally don't go in makeup, but I wanted to stream. Anyway, I love you all very much. Thank you so much for popping up, especially for a little spur of the moment one like this. I'm glad that we were able to read this together, and that was fun. That was it. They tore them apart. I think that's one of my favorite. I enjoyed Leslie Sloan's Motion to Dismiss as well, but this one was really fun. All right. Amazing. Oh, thank you so much. Thank you, everyone. Thank you. Yeah, and also if anybody's been running through all, I'm obviously not sponsored by Big VFD or anything. But if anybody else, because I know when I talk about my migraines on my live streams, I get a lot of people who relate. I have had more relief than from anything else that I've tried. I have gotten relief from my like I've gotten relief from this new like infusion thing. It's VFD. I was on, basically, if you've seen a commercial for it on TV and they've been like, this will give you your life back from migraines, I've been on it for like a year and it mostly just made me worse. All of the pen stab ones, but I have had a few really good relief moments from the VFD. So I'm always telling people who haven't gotten there yet, like, you should pressure your neurologist into letting you try the VFD, because it's kind of annoying to have to sit there for an hour every 3 months, but it is helpful. It's VYEPTI. It sounds like I'm saying letters because it sounds like VFD. But yeah, that's my unsolicited migraine advice. I gave unsolicited cat mom advice on Blue Sky the other night about about wanting to do pine litter rather than regular litter, because that is like, it makes my life so much easier with JoJo. But that's, yeah. Anyway, yeah, and I'm not feeling like so terrible that I couldn't stream, obviously, or else I just wouldn't, but especially because I was sitting here like, okay, either I'm just gonna sit and waste my entire day waiting for my appointment, or I could pass the time very quickly and have fun, and I did have fun. I love you all very much. Thank you so much for hanging out, and yeah, I'll see you again soon. Bye. I went to go turn off my video, and then I turned off the thing, because there's a delay. So when I say stop streaming, I feel like it cuts me off on the replay, so I never know how long to hang out. Okay, but that's not the one I wanted to have go away. I need like an ending screen. I think Sunny made me one at one point, and then I don't know where it is. Okay, now goodbye.